Now, let's talk about the legal side of bank guarantees in international trade. Remember, a bank guarantee always have a beneficiary. Sometimes it's the buyer, sometimes it's the seller. And whoever the beneficiary is, that's the party who can call on the guarantee. So, the question is, what kind of disputes show up? Well, let's have a look. First, consider the buyer as beneficiary. With advance payment or performance guarantees, the buyer can demand payment from the bank if they claim the seller didn't deliver. But here's the risk. If the seller actually did perform and the buyer still calls the guarantee, that's abuse. Basically, fraud from the buyer's side. Okay? Second, consider the seller as beneficiary. In some types of guarantees, like payment guarantees in other jurisdictions, the seller is protected. If the buyer doesn't pay, the seller can demand money from the bank. But listen, if the seller tries to claim payment when the buyer already paid or fulfilled obligations, that's fraud from the seller's side. Third dispute is unclear wording. If the guarantee isn't written clearly, both sides may argue about whether the bank must pay automatically or only after certain conditions. That's a classic source of litigations. And fourth, jurisdiction issues. Since these guarantees cross borders, courts have to decide which country's law applies. That can completely change the outcome. So here's the bottom line. Disputes can come from either side, buyer or seller, depending on who the beneficiary is. Fraud, unclear terms, jurisdiction fights, and abuse of guarantees are the main legal battles. And remember, a bank guarantee isn't just finance. It's law in action, and knowing the risks helps you avoid trouble in global trading.